bottom line was, if these propositions be correct, the Fifth Amendment must be understood as restraining the power of general government, not as applicable to the states. That's why he couldn't do it. The counsel for the plaintiff and heir insisted the Constitution was intended to secure the people of the several states against the undue exercise of power by the respective state governments, as well as against that which might be attempted by the general government, which meant the United States. In support of this argument, he relies on the inhibitions contained in the 10th section of the first article. We think that section affords a strong, if not a conclusive, argument in support of the opinion already indicated by the court. That means that you're screwed, people in the States. You can't use the Bill of Rights. So they go into the 9th section, in the nature of the Bill of Rights, intended to be imposed on the powers of the general government. The 10 proceeds to enumerate those which operate on the state. The restrictions are brought together in the same section, and they are expressed in words applied to the states. Quote, no state shall enter in any treaty, etc. Perceiving that in a constitutional framed by the people of the United States, not the states now, for the government of all, no limitation of the action of the government on the people would apply to the state government, unless expressed in terms. The restrictions contained in the 10th section are in direct words, so applied to the states. That's the only thing in the Bill of Rights that applied to the states, not the people.
What's the difference between the states and the people?
Pardon?
What's the difference between the states and the people? Are they seen as being different?
No. If you go read the definition in ATG Press on person, there's just a little caption on there. Scroll down and find person, and you open that up, it will tell you what the people means. People are a body politic, are part of the corporation. So if you're a people, and you refer to you as the people of the state of, or the people of the United States, that means that you are a part and parcel of the body politic in your corporate capacity, no longer having the man distinction, but person distinction, which is a fiction.
Where does that definition come from? Is that from Blacks?
Pardon?
Where do those definitions come from?
Oh, it comes out of the LaSalle Law Review it goes back to the Roman times.
Okay.
Yeah, it's all in there. It goes all the way back. It tells you where the etymology of the word originated from.
Okay.
So, the end of the court of the Barron case, we are of the opinion that the provision of the Fifth Amendment to the Constitution declaring that private property should not be taken for public use without just compensation is intended solely as a limitation on the power by the government of the United States and is not applicable to the legislation of any state. We are therefore of the opinion there's no repugnancy between the several acts of the Assembly of Maryland, given the evidence by the defendants at the trial that the Constitution and this court, therefore, has no jurisdiction of the cause, and it is dismissed. The guy lost. Couldn't use the Bill of Rights. Now, going back to the letter that I was writing to this guy, there are some rather interesting things because, they're quoting the Barron case. Now, it will tell you where the Fifth Amendments do now come in, but not as a Fifth Amendment. It's hard to understand that, but in reading this, you might come in. The court had acknowledged that it no longer felt bound by the Hurtado reasoning, the application of the states to the Fifth Amendment right to just compensation, and the First Amendment rights of free speech, press, religion, and assembly showed that some of the Bill of Rights guarantees could be applied to the states through due process of law. And now in the PAL, the court for the first time had found one of the rights of persons accused of crime to be essential to due process. The Palco case, printed below, made clear that the court was not prepared to abandon the earlier decisions such as Hurtado and Twining. Instead, it undertook to explain why some rights, such as the rights to counsel and free speech, are absorbed into due process, and why others, now get this, like jury trial and grand jury indictment, are not brought into due process. It should be emphasized that the cases absorbing rights into, now here's where the due process comes from, the 14th Amendment, do not overrule Barron versus Baltimore 1820. The provisions of the Federal Bill of Rights still limit directly only the federal government. It is the 14th Amendment which limits the states. What the court has done is to reverse the practical effect of the rule in Barron versus Baltimore with respect to part, but not all, of the Bill of Rights. Some of these rights are still not considered by the court to be so fundamental as to be required by due process of law. The court, in case after case, has been classifying the provisions of the Bill of Rights into those which are essential to due process of law, and thus bind the states through operation of the 14th Amendment, and those which are not essential to due process and by which the states are not bound. In effect, the court has established an honor roll of superior rights which bind both the state and national governments. The opinion in the present case is important since it gives an official summary of the classification up to 1937 and states clearly the principles upon which the classification rests.
All right. Now, I just focus because the 14th Amendment comes up again.
Yep.
And when you look at the language, a lot of times it seems pretty, let's just say, innocent.
Yep.
Yet we all know that something took place there.
Right.
What was it that happened to us with the 14th Amendment being ratified?
Well, really, it wasn't ratified, and it is unconstitutional. But we've got to go with what the controlling power says it is, because they're ruling everybody here, and it doesn't matter what we say, what things ought to be, it's reality as what is. So this part here would probably bring it up. In another situation for a very different purpose, the court classified the provisions of the Federal Bill of Rights in fixing the constitutional status of territories. Got that? Territories after the war with Spain. The court held that the governing unincorporated territories such as Puerto Rico and the Philippines, Congress was restricting only those guarantees in the Bill of Rights which are basic and fundamental, and which are not those which are merely procedural or remedial, such as the guarantee of right to trial by jury. See Balzac versus Puerto Rico, and the classification came in Palco versus Connecticut. One question on which the Palco case failed to answer satisfactorily was it meant by absorption or incorporation of a Bill of Rights guarantee into due process. Did it mean that the right as listed in the Bill of Rights and interpreted by the Supreme Court in federal cases was made applicable to the states? Or was the right as applied to the states a more general right, less clearly defined and permitting more leeway and discretion on the parts of the states? That's the two questions that's asked in this by these law professors. Clearly, incorporation of the First Amendment has met its application to the states exactly as it's applied to the national government. Justice Brandeis and Holmes, in their dissent in the Gitlow case, suggested that the free speech applicable to the states perhaps, quote, may be accepted with a somewhat larger latitude of interpretation than is allowed to Congress by the sweeping language that governs, or ought to govern, the laws of the United States. Didn't say the laws of the states.
Right.
The court, however, has never acknowledged such a distinction, and the same rules for deciding such cases are applied to states and nation alike, with the gradual extension of due process to include other rights. So, in other words, they bought everything in through the 14th Amendment. Now, another case is United States versus Lanza. And That was Justice Taft delivered the opinion. Here we have two sovereignties deriving power from different sources capable of dealing with the same subject matter within the territory. Each may, without interference by the other, enact laws to secure prohibition, with the limitation that no legislation can give validity to acts prohibited by the amendment. Each government, in determining what it shall be an offense against its peace and dignity, is exercising its own sovereignty, not that of the other. They're talking about the difference between the United States, Congress, and the states. The Fifth Amendment, like all other guarantees in the First 8 Amendments, applies only to proceedings in the federal government. Barron versus Baltimore brings it right up. And double jeopardy therein forbidden in a second prosecution under authority of the federal government after a first trial for the same offense under the same authority. Hey, wait a minute. What happened up there in the the Weaver case? Didn't they come in with the state and the federal?
Yeah.
Can't do it. Not according to this. Now, had that attorney or whoever it was been fighting